17. Construction where instrument is ambiguous. Where the language of the instrument is ambiguous, or there are omissions therein, the following rules of construction apply. A. Where the sum payable is expressed in words and also in figures, and there is a discrepancy between the two, the sum denoted by the words is the sum payable. But if the words are ambiguous or uncertain, reference may be had to the figures to fix the amount. B. Where the instrument provides for the payment of interest, without specifying the date from which interest is to run, the interest runs from the date of the instrument, and if the instrument is undated, from the issue thereof. C. Where the instrument is not dated, it will be considered to be dated as of the time it was issued. D. Where there is a conflict between the written and printed provisions of the instrument, the written provisions prevail. E. Where the instrument is so ambiguous that there is doubt whether it is a bill or note, the holder may treat it as either at his election. F. Where a signature is so placed upon the instrument that it is not clear in what capacity the person making the same intended to sign, he is to be deemed an endorser. G. Where an instrument containing the word "I promise to pay" is signed by two or more persons, they are deemed to be jointly and severally liable thereon. Section 18. Liability of person signing in trade or assumed name. No person is liable on the instrument whose signature does not appear thereon, except as herein otherwise expressly provided. But one who signs in a trade or assumed name will be liable to the same extent as if he had signed in his own name. Section 19. Signature by agent. Authority. How shown. The signature of any party may be made by a duly authorized agent. No particular form of appointment is necessary for this purpose, and the authority of the agent may be established as in other cases of agency. Section 20. Liability of person signing as agent, and so forth. Where the instrument contains or a person adds to his signature words indicating that he signs for or on behalf of a principal or in a representative capacity, he is not liable on the instrument if he was duly authorized. But the mere addition of words describing him as an agent or filling a representative character, without disclosing his principal, does not exempt him from personal liability. Section 21. Signature by procuration. Effect of. A signature by procuration operates as notice that the agent has but a limited authority to sign, and the principal is bound only in case the agent in so signing acted within the actual limits of his authority. Section 22. Effect of endorsement by infant or corporation. The endorsement or assignment of the instrument by a corporation or by an infant passes the property therein, notwithstanding that from want of a capacity, the corporation or infant may incur no liability thereon. Section 23. Forged signature. Effect of. When a signature is forged or made without the authority of the person whose signature it purports to be, it is wholly inoperative, and no right to retain the instrument or to give a discharge therefore, or to enforce payment thereof against any party thereto, can be acquired through or under such signature, unless the party against whom it is sought to enforce such right is precluded from setting up the forgery or want of authority. 2. Consideration. Section 24. Presumption of consideration. Every negotiable instrument is deemed prima facie to have been issued for a valuable consideration, and every person whose signature appears thereon to have become a party thereto for value. Section 25. Value. What constitutes? Value is any consideration sufficient to support a simple contract, an antecedent or pre-existing that continues value, and is deemed such whether the instrument is payable on demand or at a future time. Section 26. What constitutes holder for value? Where value has at any time been given for the instrument, the holder is deemed a holder for value in respect to all parties who become such prior to that time. Section 27. When lien on instrument constitutes holder for value. Where the holder has a lien on the instrument arising either from contract or by implication of law, he is deemed a holder for value to the extent of his lien. Section 28. Effect of want of consideration. Absence or failure of consideration is a matter of defense as against any person not a holder in due course, and partial failure of consideration is a defense pro tanto, whether the failure is an ascertained and liquidated amount or otherwise. Section 29. Liability of accommodation party. An accommodation party is one who has signed the instrument as maker, drawer, acceptor, or endorser without receiving value therefor, and for the purpose of lending his name to some other person. Such a person is liable on the instrument to a holder for value, notwithstanding such holder at the time of taking the instrument knew him to be only an accommodation party. 3. Negotiation. Section 30. What constitutes negotiation? An instrument is negotiated when it is transferred from one person to another in such manner as to constitute the transferee the holder thereof. If payable to bearer, it is negotiated by delivery. If payable to order, it is negotiated by the endorsement of the holder and completed by delivery. Section 31. Endorsement. How made? The endorsement must be written on the instrument itself or upon a paper attached thereto. The signature of the endorser without additional words is a sufficient endorsement. Section 32. Endorsement must be of entire instrument. The endorsement must be an endorsement of the entire instrument. An endorsement which purports to transfer to the endorsee a part only of the amount payable, or which purports to transfer the instrument to two or more endorsees severally, does not operate as a negotiation of the instrument. But where the instrument has been paid in part, it may be endorsed as to the residue. Section 33. Kind of endorsement. An endorsement may be either special or in blank, and it may also be either restrictive or qualified or conditional. Section 34. Special endorsement. Endorsement in blank. A special endorsement specifies the person to whom or to whose order the instrument is to be payable, and the endorsement of such endorsee is necessary to the further negotiation of the instrument. An endorsement in blank specifies no endorsee, and an instrument so endorsed is payable to bearer and may be negotiated by delivery. Section 35. Blank endorsement. How change to special endorsement? The holder may convert a blank endorsement into a special endorsement by writing over the signature of the endorser in blank any contract consistent with the character of the endorsement. Section 36. When endorsement restrictive. An endorsement is restrictive which either A. prohibits the further negotiation of the instrument, or B. constitutes the endorsee the agent of the endorser, or C. vests the title in the endorsee in trust for or to the use of some other persons. But the mere absence of words implying power to negotiate does not make an endorsement restrictive. Section 37. Effect of restrictive endorsement. Rights of endorsee. A restrictive endorsement confers upon the endorsee the right A. to receive payment of the instrument, B. to bring any action thereon that the endorser could bring, C. to transfer his rights as such endorsee where the form of the endorsement authorizes him to do so. But all subsequent endorsees acquire only the title of the first endorsee under the restrictive endorsement. Section 38. Qualified endorsement. A qualified endorsement constitutes the endorser a mere assigner of the title to the instrument. It may be made by adding to the endorser's signature the words "without recourse" or any words of similar import. Such an endorsement does not impair the negotiable character of the instrument. Section 39. Conditional endorsement. Where an endorsement is conditional, the party required to pay the instrument may disregard the condition and make payment to the endorsee or his transferee whether the condition has been fulfilled or not. But any person to whom an instrument so endorsed is negotiated will hold the same or the proceeds thereof subject to the rights of the person endorsing conditionally. Section 40. Endorsement of instrument payable to bearer. Where an instrument payable to bearer is endorsed specially, it may nevertheless be further negotiated by delivery, but the person endorsing specially is liable as endorser to only such holders as make title through his endorsement. Section 41. Endorsement where payable to two or more persons. Where an instrument is payable to the order of two or more payees or endorsees who are not partners, all must endorse unless the one endorsing has authority to endorse for the others. Section 42. Effect of instrument drawn or endorsed to a person as cashier. Where an instrument is drawn or endorsed to a person as cashier or other fiscal officer of a bank or corporation, it is deemed prima facie to be payable to the bank or corporation of which he is such officer, and may be negotiated by either the endorsement of the bank or corporation or the endorsement of the officer. Section 43. Endorsement where name is misspelled and so forth. Where the name of a payee or endorsee is wrongly designated or misspelled, he may endorse the instrument as therein described, adding, if he thinks fit, his proper signature. Section 44. Endorsement in representative capacity. Where any person is under obligation to endorse in a representative capacity, he may endorse in such terms as to negative personal liability. Section 45. Time of endorsement. Presumption. Except where an instrument bears date after the maturity of the instrument, every negotiation is deemed prima facie to have been effected before the instrument was overdue. Section 46. Place of endorsement. Presumption. Except where the contrary appears, every endorsement is presumed prima facie to have been made at the place where the instrument is dated. Section 47. Continuation of negotiable character. An instrument negotiable in its origin continues to be negotiable until it has been restrictively endorsed or discharged by payment or otherwise. Section 48. Striking out endorsement. The holder may at any time strike out any endorsement which is not necessary to his title. The endorser whose endorsement is struck out, and all endorsers subsequent to him, are thereby relieved from liability on the instrument. Section 49. Transfer without endorsement. Effect of. Where the holder of an instrument payable to his order transfers it for value without endorsing it, the transfer vests in the transferee such title as the transfer had therein, and the transferee acquires in addition the right to have the endorsement of the transferor. But for the purpose of determining whether the transferee is a holder in due course, the negotiation takes effect as of the time when the endorsement is actually made. Section 50. When prior party may negotiate instrument. Where an instrument is negotiated back to a prior party, such party may, subject to the provisions of this Act, reissue and further negotiate the same. But he is not entitled to enforced payment thereof against any intervening party to whom he was personally liable.